Hey guys, welcome to my legal classes. This is Ganesh Pujari and I was discussing about the chapter 6 of CrPC. Now chapter 6 of CrPC discusses about process to compel appearance, which has 30 sections, that is section number 61 to section 90. Now that will be too much, so what I have done is I have divided it into three different videos. Part 1 I have covered issue of summons, which is from section number 61 to 69. Part 2 covers warrant of arrest, which is from section number 70 to 81. When both summons and warrant of arrest fails, part 3 comes into situation, that is proclamation and attachment, which is from section number 82 to 90. Now, if you have not watched part 1 and part 2 videos on this, please better go to that so that you have concept clarity before getting to proclamation and attachment. When a warrant can't be executed, in such cases court have two options. One, proclamation of the person absconded or concealed, and second one, attachment of the absconded person property. Now what does proclamation means? Proclamation is a written or printed document issued by a court which sets out such requirement to attend the court at particular place and time, and attachment means taking possession of the property of such person against whom the proclamation is declared. Now, proclamation and attachment can be two independent activities or can be done together. Now, to understand the terms very clearly, let us try understand the entire concept section by section so that you have concept clarity as well as you have understanding of each section. So, let's move to next slide. The first important section when it comes to proclamation is section number 82, which discusses about proclamation for person absconding. Now, there are three important parts we need to understand when it comes to section number 82. They are when to declare a proclamation, what are the contents of proclamation, and where such proclamations are displayed. Now, question number 1, when. When a person is issued of warrant of arrest and he is absconding or concealing from such order, in that case a proclamation can be declared. Now what are the contents? The proclamation will include the place and time where such person has to report. Now the court will give timeline not less than 30 days. That is very important aspect that we need to remember. Now where such proclamation is displayed, in the village or town wherever he resides, and a copy will be displayed in the place where he resides, that is his home. And the last one, a court will also display a copy in the court from where such order is gone. So these are the three places where a proclamation will be displayed, and if court feels that it is necessary to put an advertisement or such proclamation in a newspaper, court can do that also. This is all about section number 82. While section number 82 discusses about proclamation, section 83 discusses about attachment of the property. Now, proclamation and attachment can be two different activity, or court can declare attachment along with the proclamation also. Now, when it is done, whenever court feels that the person who is absconding is trying to dispose his property or trying to move any of his property, in such case, court can declare attachment. Now, in case of movable property, court can actually seize the property or appoint an official receiver or prohibition of delivery of such goods. In case of immovable property, court can actually take the possession of the goods and appoint an official receiver or prohibition of the payment of rent on delivery of property. All those stuff is possible. Now, section number 84 discusses about selling of that property only after 6 months. But if the property has some livestock or goods that is of perishable nature, in such case, court can sell the property within 6 months also. That is a kind of exception available in section 83. Now that I have already touched a little bit on 84, let us try understand section 84 in detail in my next slide. Now that we know what is proclamation and what is attachment, now I am discussing an interesting scenario when it comes to section 84. Imagine Mr. X is the person against whom the court has declared proclamation and attachment, and suddenly A comes to the scene and says, I have interest in such attached property. What to do in that case? When should A come and raise that query? Within the 6 months of attachment of that property, A should raise his query on the interest of the property, and court will decide whether A has interest in that property or not. Now, second part of section 84 discusses about when to dispose such attached property. If there is no query raised by anyone, that means if nobody is raising claims and objection against that property, court can dispose after 6 months and court shall try to dispose within 1 year. If there is any claims or objection arised, in such case, court cannot dispose until the matter is closed. That means the matter need to be settled only after that a disposal can happen. However, while I explained section 83 already said that if there is any livestock or goods of perishable nature, for the benefit of the owner, court can sell the property prior to 6 months also. That is an exception available. With that, let's move ahead. The three important aspects pertaining to attached property, that is release, sale and restoration of the attached property, is discussed under section number 85. Let us try understand one by one. The first being release. Imagine there is a proclamation against Mr. X and he comes to the court within the specified time. In such case, court will immediately release such attached property. If X is not coming even after 6 months of proclamation, in that case, court can sell the property and court can sell before 6 months also if there is any livestock or perishable goods available. The third part, which is very interesting part, that is restoration. If X is able to prove that within 2 years, he has to come and prove to the court that I was not absconding or concealing from any warrant and I was not aware of the any proclamation which is against my property as well as me, the attachment, anything. I don't know anything of all this. If he able to prove all of this, in such case, court have different option. One, to release the property immediately if they have not yet sold the property. If they have already sold the property, they have to pay all the money that they have got from selling such property. And if they have partially sold the property, they need to give that partial money to him as well as the remaining property to him. However, in case 2 and 3, that is selling of property, wherever the money expended by the court will be deducted from the person who is coming. That's very important. With that, let's move ahead. Now let us try understand some other important provisions from section number 86 to 90. 86 discusses about the person who came within 2 years saying that I was not absconded or concealing. In such case, if he fails there to prove, he can again put a case. That is an opportunity available as per section number 86. Section number 87 says usually court should give summons first and warrant next. Only in such case where court doubts that the person is trying to abscond, in such case summons and warrant can be issued together. That is discussed under section number 87. Section number 88 gives power to the court to take bond for appearance with or without surety, and section number 89 gives power to arrest such person who is trying to escape from appearance even after giving bond, and section number 90 says whenever the word summons or warrant is used in entire code, it should be read with chapter 6. That can be the issue of summons or warrant or service of summons or warrant, or maybe execution of summons and warrant. Any question arises, they need to be referred with chapter number 6. That is very important. With that, let's move to the case laws. I have 4 interesting case laws for this video. That is Siddhanagowda versus State of Mysore, where it was held that the person against whom the proclamation is declared need to come to the court within 30 days. That was the first fact. And second fact, if the proclamation is illegal, in that case attachment is also illegal. These were the 2 facts held in Siddhanagowda versus State of Mysore case. The second case happened in Bombay High Court, Heya Bai versus Secretary of State, where it was observed that if nobody raises claims or interest in the property which is attached within 6 months, such property can be sold. The third case, Karyali versus the National Bank, where Kolkata High Court held that even after failing in the suit by the interested party, he will have another 1 year to prove his interest in the property. That is with the Karyali versus the National Bank case. The last one, Kashmira Ram versus State of Punjab, is a classical example for section 85, where proclamation issued in India but petitioner was in USA and he came within 2 years and proved that he was not aware of any proclamation or attachment. So that is one case for section number 85. With that, I am concluding this video. Hope this video will help you in your exams. Thank you so much for watching me. If you want to watch the same content in Hindi, please subscribe my other channel, Kachi Hindi Pakki Law. Videos there will come by October 2019. I am still working on them. Thank you so much for subscribing me. Please like, share and comment my videos, and all the very best.